He rejected a 35-year deal. Now he's risking life in prison on 4 felony charges. Will he regret it?
All right, sir, you're John Jones?
Yes, ma'am.
Give me just a second. Let me get your everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 25 DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet in those cases some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer if you wanted to enter pleas of guilty for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right. Is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would come out in one occurrence, and then there's one from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024.
Sentence stacking alert. This is where things get really serious. If Jones is found guilty on multiple counts, the state can stack the sentences, basically layering prison terms on top of each other. One mistake and you could be looking at decades behind bars. Legal geeks, this is classic cumulative sentencing in action.
You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right. And do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
Like, it's my offer 35, right? Like that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year offer.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would. Listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will begin preparation. That, you can go back with the bailiff. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second, let me get that pulled up.
Our agreement, Your Honor, is for her to go on special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
Judge, we've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had the statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. All right, sir, are you Jerry LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty in cause number 21-38605 to the state jail felony offense of theft, and in 22-40408 to the state jail felony offense of abandoning or endangering a child. The agreement in those cases was for a cap of 15 months in the state jail prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir.
Are there any additions or corrections?
Not from the state.
No, Your Honor.
All right, Mr. Jeffries, you may proceed.
Your Honor, I believe the most appropriate ending to this is probation. As the PSI report indicates, he would be a low risk on probation. I think just for context, a little bit of history on Mr. LeBlanc. He grew up in foster care. He did get into some trouble in his teenage years into the very early 20s. I believe the last time he got in any trouble, he was 21. He's in his 30s now. It's been 10 years since his last issue, and that was not a major issue that he had. And like I said, he was very youthful at the time. These situations, it's not a situation where he's going to go to prison forever and not come back. He's going to be back in society at some point. And what we ask is that we give him an opportunity to grow. Growth is important, and growth sometimes comes through very troublesome circumstances. In Mr. LeBlanc's case, the child involved in this particular situation has passed due to an illness, and that passing has given him perspective that most of us want nothing to do with. And it's allowed him to reevaluate his life and to see the mistakes that have been made and to grow from it in a way where he's actively contributing to his community. He's volunteering with kids. He's giving up his time and his finances to coach youth football.
Switching gears, here's Mr. LeBlanc. Unlike Jones, he's had time to reflect. His child passed, he's giving back to the community, coaching youth football. This is your classic redemption arc, but don't let it fool you. The other side is ready to remind the court about past mistakes. Real-life drama, folks.
Taking these kids all over the place, trying to teach them the way to do things to prevent them from following the same path that he's taken. Along with that, he does have a 5-year-old daughter that he's very active with, that he has custody of 50% of the time, and he's a strong financial supporter of her. And what we're asking the court to do is to take all that into consideration, along with the fact that the PSI has him indicated as a low risk for probation, and just allow him to continue that growth.
Thank you, Mr. Jeffries. Mr. Smith?
Judge, the child that passed is the child that he left alone in the car in a parking lot at Academy while he and 2 friends went in and stole hundreds and hundreds of dollars worth of stuff, or attempted to steal. He basically says that was his buddies. He wasn't even doing it. They were all obviously working together. They covered the license plate with a rag so that they could make a speedy getaway. They didn't just go in and grab a few things. They had duffel bags full of clothing and items from the academy. He's been given probation opportunities before and was revoked. His criminal history speaks against him, and I believe I would ask for state jail time in this case.
Thank you, Mr. Smith. So I'm looking back, I'm not sure what has been the delay. These offense dates are from 2021,
Yes, ma'am.
and it appears that
Both,
August 27th, 2021.
and I believe November of 2022, Routine got 20 months state jail, and then Brooks got probation 2 or 5. That was a cap plea.
Okay.
Your Honor, if I could add just a information. Mr. LeBlanc's position, he understands that he's accountable for this theft. His statements are just an indicator that he did not take any property away from Academy. He knows his cohorts did, and he understands that he's accountable for that.
Okay. I guess what I'm looking at is just the length of time. I mean, obviously there's criminal history, and I don't disagree with Mr. Smith that on paper this does not look like you should be considered for probation in some ways because of you've been given an opportunity for probation. And just listen. Don't talk yourself out of what I'm about to do. But what I'm trying to say is that those revocations, the one revocation was back in 2014. Obviously, that's a long time ago. You were much younger. You have apparently not been in trouble since the date of these offenses, at least not here that probation discovered. And so you've been out on bond or doing whatever for some amount of time, doing the right thing. I appreciate that you're giving back. I appreciate the things you're doing, and it looks like you've grown up. You've gone through, I understand your child passing away. None of those things, however, makes it okay what you did. All right, so in cause number 21-38605, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offensive theft. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You will be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 22-40408, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of endangering a child, state jail felony. Sentence you to a term of 2 years in the state jail prison, but I'm going to probate that, put you on probation for 5 years. You're also ordered to pay a $500 fine in that case, and you're ordered to follow all of the rules and conditions of probation. Part of those rules and conditions, you are to have no contact whatsoever with the co-defendants, Kendall Pushy and Marquise Brooks. You're also not allowed to go to academy. And I'm also ordering that you have to find, you're not allowed, I don't know if you're still using medical marijuana. You cannot use that.
Yes, ma'am.
Because the facts in this case looks like you were doing more than just using medical marijuana. Hang on. When there's scales and stuff involved, that's not somebody that's going to get medical marijuana. And that's what was inside the baby's backpack. All right? Okay. So if you test positive for marijuana, it is a violation of your probation. You will be right back in here facing the 2-year sentence that I gave you today. No negotiation. I just gave you the max, 2 years. Okay? If you follow all of the rules and conditions of probation that you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve those 2-year sentences while you're out on probation. But again, the other side of that is if you violate any condition of probation, you'll be brought back here and you'll be facing those 2-year sentences that I just gave you. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Jeffries. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir. Thanks, Mr. Smith. Thank you, sir. Mr. Kimler, you've got Aaron Ashcraft. This is pretrial.